Good morning, everyone. We are delighted to welcome you to the IIB's webinar, They Still Want What? Considerations for FBOs on how to respond to a cross-border civil, criminal, or regulatory request for information. By popular demand, this is a part two to our webinar in January, They Want What? And if you missed that presentation, you can watch it on the IIB's YouTube channel. We again have with us today three people with considerable experience in this area. Our moderator, Jeff Alberts, is a partner at Pryor Cashman. Jennifer Heil, head of litigation, human resources, and government investigations in the Americas legal department at MUFG Bank. Lee Renzen, deputy global head, global investigations and regulatory enforcement at HSBC. Their full bios are in the meeting invite, so feel free to check that out. Some housekeeping before I turn it over to our speakers. Today's webinar is eligible for New York CLE credit. If you would like to receive CLE credit, listen for the 5-digit code that our speakers will provide during the course of the presentation. Use that code to complete and submit the affirmation form, a link to which is included in the meeting invite, and also please complete the online evaluation form, which is also found in the links in the meeting invite. If you have any questions, please email us at info@iib.org. And with that, I will turn it over to Jeff.
Thanks, Stephanie. All right, good morning, everybody. Before we get started, I just wanted to put things in context a little bit, because as you may have inferred from the fact that this is, they still want what? And the last presentation was, they want what? The focus today is on a later phase in the response to the subpoena. So we previously had a discussion that ran for about an hour and a half, where we got into what to do right away. So when you get a subpoena, what are the things you should be doing that day? Who should you be reaching out to? And we also discussed what the different types of subpoenas and document requests are. So if you weren't able to see that, it's a great background to the discussion today. And if something terrible happens and you get a high pressure subpoena in the future, one thing you could do right away is go watch that video, and it'll help give you some ideas about things that you should be doing to respond so that you have all your ducks in a row. But after you've done that, and after the immediate terror of responding to one of these high pressure subpoenas is passed, there's a number of other steps you should take, and we're going to be talking about some of them today. The first thing that we're going to be talking about is some different techniques that you can use to narrow the request. So often when you first get a document request or a subpoena, there will be a very broad request that would be very burdensome for a bank to respond to. But there's a number of different techniques that you can use to negotiate with the government or with the civil party that sent you a subpoena to narrow those search parameters in a way that reduces the burden on you. So Lee Renzen is going to discuss that.
Yep, sure. So, yeah, I mean, in a nutshell, it's just important to know and not lose track of the fact that there is a lot of room to pick up the phone and discuss. Subpoenas and other requests are rarely written with a clear understanding of what the burden will be on the bank, on what the likelihood is that the bank might have, what it is they're looking for. So prosecutors, regulators, draft broadly. They will never, that I can imagine, be surprised to receive a call saying, can we talk about this? Or can we talk about, the parameters? The subpoena says all records going back to 2010. Well, it's easy for us to do going back to 2019 or 17. Beyond that, we have to go, open up the warehouse in the hinterlands. Things like date range, things like custodians, any number of topics depending on the subpoena are always up for discussion, as well as timing. So things like, look, we can get you this early. Can we get you this can we get you emails first, and then, once you look at those, can you tell us whether you really need audio as well, or can we get your records going back 5 years, and then let us know if you need. So things like that are, two things to consider that I think are really important are, number one, keeping a record of what it is that you agreed to when it comes to negotiating, and it's simple as, sending an email saying thanks for the call as we discussed, blah, 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 is helpful. And also, while these are generally informal conversations and, it doesn't have to be a very sophisticated discussion, or our credibility is so key, and maintaining credibility is so key that, if it really is hard to go back, say, more than 5 years, say it. But if it's not really that hard, don't make it out to be harder than it is, because at the end of the day, stuff like that comes out and it just comes back to bite us. So if nothing else, if you look at a subpoena and you think, oh my God, this is going to take me forever, it's okay to pick up the phone.
Yeah, and one thing that I'd point out too, and I know Lee and I both had this experience when we were working as federal prosecutors, is that in addition to not being surprised when you get a call from a financial institution and they're seeking to narrow a request, often it's very helpful. So sometimes you'll send out a subpoena and you'll say all documents related to a certain topic, and what you have in mind is a very narrow category of documents. And if what you get back is 1 million gigabytes of data from some hyper specialized database that you had no way to expect, that might be annoying to you. Or if you get 10 million emails back and what you really wanted was a fairly narrow category, again, that might be frustrating. And you might think that the bank is trying to hide the ball by flooding you with irrelevant documents. So it not only can be helpful to the financial institution, but it also can be helpful to the agency that sent out the document request or the subpoena. So often you get, not only will they not be surprised, but they'll actually be grateful that they're able to have that kind of dialogue about the nature of the documents that they'll be receiving.
Right. Just one quick recent example, just to show. We got a request for all emails between, a long list of people. We called up and said, this is going to take us a really long time. Can you help us? And they said, well, actually, the government had already seen certain emails that, included certain keywords. And they said, well, why don't you start with this? And it really, allowed us to narrow down, gave us a good starting point. And it was, fine.
I think that a few years ago, maybe sort of at the advent of e-discovery, there was an assumption of, oh, more is better, meaning to receive more is better because then there's more that you can search through and sift through. But I think that there has been a change, and there really is much more of a preference for, hey, we're looking for this narrow, topic area. And then if you say, hey, if I give this to you, it is going to involve millions of pages of documents. Do you really want that? Sometimes they'll say yes, but most often they'll say, oh, no, I don't want millions of documents anymore. I want, can you just narrow it down or whatever? So they do appreciate it very much.
In the course of engaging in these negotiations, factors like burden are very important. But one general legal category that is often used to formulate objections to a request has to do with jurisdiction. And I really today do not want to get too bogged down in the specifics of case law, because I think one of the real values of this type of program is getting insiders that are inside counsel at bank and very familiar with interacting, not just with regulators, but with other people at their financial institutions. And so we want to focus on that type of practical advice. But a background to a lot of those practical questions is this legal standard of jurisdiction. And there happen to have been some major developments just recently over the past couple of years that are relevant in particular to foreign banks. So I want to run through some of those legal developments, and you have to start with the background of what jurisdiction is under US law, because I know a lot of people that are on this call are not attorneys. And the general backdrop is the US Constitution. And the idea here is that it's not fair to exercise jurisdiction over some company or some bank that is located entirely outside the United States, doesn't have any presence in the United States, isn't doing business here. Like imagine some little, one branch Australian bank that just has Australian customers. It doesn't seem consistent with the notions of fair play to haul that bank into a United States court or force that bank to produce documents in the United States. So the US Constitution puts these general limitations on the ability of people in the United States, including the US government and banking regulators, to seek documents that are located outside of the United States. And there's two general standards, general personal jurisdiction and specific personal jurisdiction. The standard for general personal jurisdiction is that the foreign bank's affiliations with the United States are continuous and systemic. So if basically what that means is if the bank has a very significant presence in the United States, it continuously has that presence in the United States, then it's likely to be subject to jurisdiction over any type of litigation or any type of subpoena that is served on that bank. And then there's a more narrow category, which is specific personal jurisdiction. And that relates to when there's a subpoena that is served on the foreign bank that relates specifically to that bank's activities in the United States. So if you have a subpoena that is served on a bank and it is requesting information about activity that is entirely based on the bank's operations in Australia, for example, and an Australian account holder and has nothing to do with the United States, that wouldn't necessarily fall within the specific personal jurisdiction category, but it would fall within the general personal jurisdiction category. So that gives you a general sense of the backdrop. And one thing, because it's a constitutional limitation that is intended to protect this notion of fairness, it is waivable. And that ends up being significant under a number of the different categories of requests and subpoenas that you can receive. So let's talk about those very quickly. The first is grand jury subpoenas. We've already discussed them to some extent. And basically, for most of the people that are on this call, it turns out they've already consented to receiving grand jury subpoenas and to jurisdiction with respect to grand jury subpoenas if they relate to US banking law. And that's because when a bank applies to open up a branch or an agency in the United States, it generally, as part of that application process, consents to jurisdiction. And so to the extent that you receive a subpoena that relates to a criminal, that relates to a request from a banking regulator, but also that relates to a request from a federal prosecutor that has to do with a money laundering investigation or an investigation into a violation of banking law, you clearly will have jurisdiction.
Hey,
or
Jeff,
they clearly will have jurisdiction over you. Sure.
Yeah, I know that actually came up in the DC. I think it was the DC District Court opinion in the three Chinese bank cases, three Chinese banks case. And I think the court pointed to that. Have you, as far as I'm aware, that was the first time that ever that was ever either litigated or reflected in a judicial opinion. Have you seen it before or since? Just curious. So I haven't seen a more recent application. That was a 2019 decision, at least the DC Circuit decision. And it was an interesting decision in a couple ways. One was that it ended up focusing very specifically on the relationship between China and the United States. And so one thing to keep in mind when applying that decision is that it may not be applied in the same way to other jurisdictions. And in particular, one of the objections that was made by the bank was that producing these documents would violate Chinese law, so we shouldn't be forced to produce the documents, which sounds like a very reasonable objection. But the court actually rejected it for a couple of reasons. And one of them was that because this particular bank was state-owned, it was less likely that employees of the bank would be criminally prosecuted. And so obviously that wouldn't apply to a lot of other banks that are on this call because they're not state-owned.
And this also relates to the next topic we're going to talk about, which are very similar category of requests, which is Patriot Act subpoenas. So that case actually happened to involve both a grand jury subpoena and a Patriot Act subpoena. And grand jury subpoenas are subpoenas that are issued in connection with federal criminal investigations by grand juries located here in the United States. Patriot Act subpoenas are a little bit different. They can be issued both by the Attorney General or by the Treasury Department, and they relate generally to investigations of violations of the Bank Secrecy Act, civil forfeiture actions, various forms of money laundering investigations. And they were both interpreted in that DC Circuit case, but then subsequently in January of this year, the NDAA changed the scope of those requests in a pretty significant way. Though Patriot Act subpoenas previously had enabled the Attorney General or the Treasury Department to request documents from a bank that had a correspondent banking account here in the United States, if the request was for records that relate to that correspondent banking. Now it appears that that's been expanded to apply not only to a request of a foreign bank that has a correspondent account in the United States when it relates to the correspondent banking, but it can relate to any account at that foreign bank, which is a potentially massive expansion of the ability of the Attorney General and the Treasury Department to get documents from foreign banks, because it would seem that they now can request documents that relate to accounts that have nothing to do with the correspondent banking activity that that bank has here in the United States. And that's very new. And I think that there's likely to be litigation over that, because it's not clear whether that broad scope of the ability of the US government to make requests of foreign banks is consistent with the US Constitution. Because merely by virtue of having a correspondent banking relationship in the United States, it's not clear that it's consistent with the US Constitution to allow a US regulator to request documents that have nothing whatsoever to do with that correspondent banking relationship or with that entity's activity here in the United States. One other thing that is significant about the NDAA that is likely to be relevant to a lot of people that are watching this is that it states that a potential conflict with foreign secrecy law or with foreign confidentiality law can't be the sole motion or the sole basis for a motion to quash the Patriot Act subpoena. So if either the Treasury Department or the Attorney General issues a Patriot Act subpoena and requests documents that it's actually illegal and would violate a foreign law to produce here in the United States, that can't be the sole basis for the motion to quash or modify under the terms of the Patriot Act itself. And that obviously puts a bank in a tough spot.
So Jeff, we've actually already started receiving questions about this from some of our foreign counterparts, the lawyers in some of our foreign branches, basically asking, well, what's going to happen if we get one of these things? And, knocking on wood, luckily we haven't had to deal with this issue yet, but it is something that's kind of creating, ripples across the globe, because people have heard about it and have said, we are in jurisdictions that have actually quite strict data privacy laws or what have you. What are we going to do if we receive a subpoena, this type of subpoena, and we have to respond to it? And frankly, it's untested at this point, other than in the case about the Chinese banks that we mentioned already. But it's untested, and so I wouldn't be surprised if there still is an argument about foreign secrecy or confidentiality or data privacy rules. But we'll see how that comes out. So it is potentially putting in-house counsel at these type of institutions in a very difficult situation.
Yeah, definitely. Sorry, my network connection was unstable for a second there, so I missed part of what you said. But I know that Lee is going to be leading us in a discussion just a little bit later about some of the techniques that you can use to try to navigate those difficult waters. So I talked about grand jury subpoenas, Patriot Act subpoenas, two other categories of subpoenas that potentially you would need to respond to are civil subpoenas. And so, in addition to a government agency or a federal prosecutor, you can receive a subpoena just that relates to a litigation between two different companies that are based here in the United States. And the limitations on the ability to obtain documents that are located outside of the United States are set forth in Rule 45 of the Federal Rules of Civil Procedure and case law that is interpreting that. But basically, when the subpoena is served on a US bank or a branch of a foreign bank that is located in the United States, the primary focus is on the custody and control of the documents. So if you are a branch of a foreign bank and you receive a subpoena, if you generally have the ability to access those documents, so for example, they're kept in a shared folder on the cloud that you have access to as the branch and that the Home Office has access to, then you're likely to be treated as having custody and control of those documents and be forced to produce them. But if the documents are outside of the United States and you have no ability to obtain those documents directly, then often you'll be able to resist the effort of civil litigants to obtain documents from the US branch of the foreign bank.
So Jeff, this is something that I'd really want to emphasize because our bank has been in the process with respect to a number of our internal systems of globalizing those systems. And really it's something where the idea behind it is to make it easier to support our clients globally. And so it will allow our bankers to go into one system, for example, and say, okay, what are we doing, not just in the US, but what are we doing global? What are we doing in Europe? What are we doing in Middle East? What are we doing in Africa? What are we doing in Asia with respect to this client? And it's actually really valuable tools that we're starting to build globally to support, not only, but, to support the bankers. We're also doing it, for some of the in-house support systems like compliance, or KYC or whatever it might be. We're making a lot of information available to a lot of people globally and on purpose, but sometimes proactively, sometimes reactively, but sometimes proactively, people who are setting up these systems will come to legal and they'll say, hey, is there anything that we need to consider? And I really think, as being in-house counsel of foreign-owned bank, one thing that we really need to kind of warn people about is, just so you know, if by building these global systems, people in the US are going to have ready access to documents that otherwise, that are sensitive maybe, and that otherwise prior to the building of the system, they would never have access to. And, and maybe it's fine. A lot of times it's not a big deal, but maybe it's something that either because of a foreign statute. I mean, obviously we have to be careful when you're building systems on that, and that's not what the CLE is about. But that is something to be careful about. But even just with respect to responding to subpoenas, is that and we have had it where 5 years ago, had we received the same subpoena, we would have sent a letter back saying, we looked in our systems, can't access anything, it's right out in Japan or London or wherever, fast forward 5 years and we'll get a very similar subpoena and we actually have to go and dig up all this information and produce it that we wouldn't ordinarily. Yeah. So it's been a real big difference. And I think that's likely, I assume that it's likely happening in a lot of foreign owned institutions and even in US based institutions as well. So.
Yeah, it's a really complicated issue, and you think about all the sort of different stakeholders who you would need to weigh in or think about it, right? I mean, you have the folks like us who are saying, wait a minute, this is something to think about. Typically, if you raise that with the people who are building the systems, whether they're IT folks or they may not necessarily be the same people who have the vested interest in the data, right? I mean, So they're the ones who are, and understandably, their mindset is on how can we build a system that, facilitates information flow in the best way possible. The folks maybe in the US are the people, who benefit from having access to it. It's the people who, own the data or whose data it is somewhere else who need to think about that risk. And so it really is kind of bringing everyone together to think about, because it's not sort of a, it's not top of mind for people, and why should it be? So it really is making sure that you have the people who would be upset if the data, who might be upset if the data, was available, or, that they're the ones who have a say in, the systems. And then also, to your point about, 5 years ago, maybe we would have just sent a letter saying we don't have it. Another thing to be sort of mindful of is, are the people who are sending those letters aware of how things have maybe evolved? Depending on how big your institution is and who handles, if you have, a team that handles subpoena responses, are they, how looped in are they to, evolutions in data flow and availability? So.
That's right. That's right.
Yeah, that's an excellent point. And it's something that I don't necessarily, as outside counsel, I generally get pulled in on kind of the responsive basis when a subpoena has been served. And often my thought is, it's too bad that the bank systems were built this way. But I think it's important to think proactively, particularly for larger financial institutions, and understand some of the implications of increasing the ability of a branch or a subsidiary or an agency in the United States, their ability to access the documents that are primarily in the custody of the Home Office. And that relates not just to civil subpoenas, which I just discussed. It also relates to something called a Section 1782 order, which is something that you should be aware of. Basically, a Section 1782 order is an order that you can obtain in a federal court that allows you to allows a litigant in a foreign litigation to obtain documents here in the United States for use in the foreign litigation. So before we were talking about civil subpoenas, which are being served in connection with the US litigation, these are requests that are served through a 1782 order to obtain documents for use in a foreign litigation. And the standard, again, it tends to be what the custody is of the bank located here in the United States over the documents that are located outside of the United States. So there are so many standards and there are so many cases interpreting those standards. I don't want to get into the weeds, but at a very high level, here's a few things that you should do when you're thinking about using jurisdictional arguments in response to a document request. First of all, you want to right away go out and identify the facts that are relevant to your jurisdictional arguments. So that includes information about the documents themselves. So Jennifer and Lee did a great job talking about various ways in which often the local branch or the local agency can obtain access to those foreign documents. And sometimes the lawyers don't even know the answer to those questions, or the people at the branch don't know the answers to those questions. So they may have access to the documents and not know it. So they need to pin that down right away. And they also need to understand what the nature is of the foreign bank's control over that local branch or agency, because sometimes the control of a foreign bank can be so extensive that a US court will end up treating that branch or agency as part of the foreign bank, and that can change the entire analysis. So you want to pull that information together right away. Next step, consult with your counsel about whether or not you have a strong case once you've pulled those facts together to object to the request. But then last of all, you just want to make sure you pick your battles, because sometimes you might have a great argument about jurisdiction, but all they're asking for is like a 1 monthly statement for one account holder, and you're allowed to produce it. So it might just be easier to produce it and not fight to the death over the jurisdictional bases for making these arguments. And the other side of that coin is you shouldn't be afraid of litigation. Some banks, especially banks that are based outside the United States, will have an attitude towards the possibility of litigation where they're just like, we would never do that. We would never litigate to object to a document request, because in our jurisdiction, that would be viewed as incredibly insulting or result in some kind of sanction on the bank. But in the United States, the attitude is different. It often is possible to litigate, in particular, if it's not your prudential regulator, if the request is coming from some other agency or from federal prosecutors, you may well be able to push back. And often, if you have a legitimate basis for making those arguments, you won't face any significant penalty. So while you don't want to fight when it's totally unnecessary and the fight is going to end up costing more than the benefits, you also shouldn't rule out the possibility of litigation, because often people do in those litigations. And I think most federal prosecutors and regulators are very understanding that financial institutions have the right to make those arguments, and they don't hold it against the institutions for making those arguments. Or at least, yeah, go ahead, Lee.
I just want to pick up on something you said earlier. If they're picking your battles and maybe you have a fight to make, but if they just want one document or something, which raises a question about waiver of jurisdictional defenses. And maybe we could speak just for a moment to if you do that in one case, are you doomed down the road? Which the answer generally is no. Right. I mean, you can sort of waive certain things on a case by case basis, but it's certainly something that it's worth, probably beyond what we can get into today, but it's worth, giving some thought to. It's not.
And actually, in my bank's case, we tend to not be very litigious at all. But in my bank's case, actually, a few years ago, we decided to move to quash a subpoena kind of on similar basis that there was information being requested that was held outside of the United States that was not actually easily obtainable in the US, but there was a lot of pressure with respect to this particular thing. We decided to fight it. It actually ended up going up to the Seventh Circuit. We received a favorable ruling, and now it's actually really helpful for us because we've created precedent, not just for other banks, but for ourselves to say, look, the Seventh Circuit found that in this same situation, we didn't have to turn over documents. Why should we have to turn them over here? So, in terms of, not being afraid of litigation, it actually can be very beneficial. And I know that other banks have actually, it's called the Litigation case, by the way, that they've used that Seventh Circuit case, to kind of bolster their own either, meet and confer motion to quash, discussions with opposing counsel, or even, in litigations if they end up going that far. So yeah. It's definitely something to think about in terms of not just, not just whatever the current subpoena is, but will you potentially create good precedent for you and other banks down the line?
Yeah, one other area where precedent can be particularly important, and I think this is a very hot issue right now and a difficult issue for foreign banks, is how to handle the situation when you have a conflict between a request from a US regulator or a federal prosecutor and a foreign law that relates to data security or data privacy and limits the ability of that foreign bank to share documents. So it can put the bank in the situation where there's a tension between, do we want to potentially violate US law that requires us to respond to the subpoena, or to violate a foreign law that limits the ability of the foreign bank to turn those documents over. And Lee's going to answer all of your questions about how to resolve that difficult situation.
Yes, all I don't know, but I will try. I mean, I think, there's no perfect answer, and I don't know that anyone has ever sort of threaded the needle perfectly. I think it really is about being open and, with regulators on both sides, and sort of, picking battles and sort of weighing how strongly the restraints are on one side versus how, by strong, I mean, how firmly established are they? Are the penalties criminal or civil? What's the history of enforcement in that jurisdiction? Obviously, the stronger and the penalties, and the more of a sort of robust history of enforcement there is on the home location of the information, the stronger a case you would have to make to the requesting jurisdiction that it needs to be limited, and vice versa. I think what's really important again is credibility. I think that at this stage, regulators, especially in the U.S., know what it means when you say Swiss law says something, versus other jurisdictions where maybe there isn't as robust. Some places, and things change. Obviously, things are changing, and in certain jurisdictions, there are times when having being able to provide an opinion from local counsel in the jurisdiction can help. So I think it really is. It's a balancing, unfortunately, like so much else that we have to do, and weighing the risks on both sides.
Yeah, it really does end up being a risk-based decision that we make a lot of times on those type of things. So, the jurisdiction that I happen to deal with the most is because our home office is in Japan. They do have a fairly extensive data privacy rule there. And by the way, I don't purport to be an expert on Japanese law in any way, shape, or form, but we've had to deal with it quite a bit. And even though there's an extensive data privacy law, sort of as Lee was saying, it's not something that we've seen to be enforced that much. And usually the way of enforcement would be for a Japanese individual to bring litigation, which is actually quite unusual in Japan. And so a lot of times we've really, if we have a US based subpoena that calls for the production of information relating, that might come under the Japanese data privacy law, we really have to weigh it, because there's nothing saying, oh, you absolutely are allowed to do this under Japanese data privacy law. But here we've got, a very serious agency subpoena or something like that asking for this information. And we say, okay, what are the risks? There's a risk that a Japanese, individual might sue us in Japan, or there's the risk of not complying with the subpoena from a US agency. And, it's a tough decision, but, we have to act one way or the other. And so, I don't have all the answers on that either, but it is something where, to be able to live our daily lives and be able to do our jobs in terms of responding to these type of subpoenas, we have to look into it and then kind of make a risk-based decision.
Sure. Yeah, another area in which there can be a real tension where you have to kind of balance the competing interests of different parties relate to subpoenas that somehow implicate confidential supervisory information. So as most people on this call know, there are restrictions on the ability of a financial institution to share what's known as confidential supervisory information, which includes reports of examination, and often can include information within a report of examination, and things like MRAs, and discussions back and forth between a prudential regulator and a bank relating to the resolution of a MRA or matter requiring attention, or to the report of examination or specific facts within the report of examination. And there's a couple of ways that a subpoena can implicate confidential supervisory information. The most common way is when the subpoena requests information that constitutes confidential supervisory information. So it could just say, send us all your reports of examination. And that would, responding to that would involve sharing confidential supervisory information. A second way in which a grand jury subpoena, for example, can implicate confidential supervisory information is when the subpoena itself reveals information that constitutes confidential supervisory information. So, for example, if a subpoena specifically requests documents that relate to certain findings within a report of examination, that would reveal that those findings were made within a report of examination. So either way, when you as a foreign bank are in a situation where you think that confidential supervisory information has been implicated, there's a few things that you should do. The first thing that you should do is notify the US agency that is making the request that the bank is going to need to seek authorization to share the confidential supervisory information. And the reason why you want to do that first is because the grand jury, the agency, or the federal prosecutor that is sending you the subpoena may be upset if you reveal the existence of the subpoena and of the existence of the investigation without letting them know first. You also should, sorry, go ahead, Lee.
Oh, no, I'm sorry, I was just coughing.
Oh. The other thing the other reason why you want to notify the federal prosecutor is often it results in a delay of certain information. So, if they request all of the board records that relate to a certain topic, but some of them contain confidential supervisory information and they want it next week, it's useful to be able to explain to them this may take longer because we have to engage in a process with our prudential regulator where we get their authorization to share those board minutes that specifically contain confidential supervisory information. The next step is to request the authorization to share confidential supervisory information. So you go to your prudential regulator. They usually have a specific mechanism for doing this, but it involves sending them a letter explaining why you want to share the confidential supervisory information. Then they'll give you, hopefully, the authorization. And once you have the authorization, that often comes with limitations. So they may limit your ability to share confidential supervisory information to specific parties. They may require you to destroy the information or have whoever received the information destroy the information once the investigation's over. And so that requires you to keep track of the confidential supervisory information. So for example, often when you're producing documents in response to a grand jury subpoena, you would make use of some e-discovery vendor, which is a third party. So you need to make sure that your authorization to share confidential supervisory information includes that vendor. And then you need to keep track of all the confidential supervisory information that you provided to that vendor so that at the end of the investigation, you can direct the vendor to destroy that documentation.
One thing, Jeff, that I've noticed recently with respect to when CSI is implicated in a subpoena or document request is when we've approached our prudential regulators to say, hey, we've received this request, we'd like to get a CSI waiver from you. Their response has been, we're not giving you a waiver, we'll send it ourselves. Tell them to send us either a formal request or even a subpoena, and we'll send it ourselves. That way we can have that direct, we can see exactly what's being sent. And that I've actually seen increasingly over the past year or two. And I think sometimes it depends on, the attitude of your supervisory team that you deal with and, how careful that they want to be. But we've really seen that. And then another thing too, is that at least with respect to the sort of big, US prudential regulators, they do have a very expansive view of what is included in the definition of CSI. And so, for example, Jeff, you mentioned, maybe enforcement actions or MRAs. Some of the regulators, including some of the big ones, consider not only, for example, supervisory letters or reports of examination or something like that, but they consider any remedial action plans that have been developed by the bank in response to the MRAs or the enforcement actions to be CSI themselves. So even if it's information that was created by the bank, so it's sort of a strange thing to have to go to your regulator and say, so I know we created this material, extensive set of action plans of what we're going to do to remediate whatever issue that we had under an MRA, but we recognize that this is CSI. Can we please hand it over to, whatever agency is looking for it? And that can actually be something we've actually had issues with it inside our bank because a lot of people have not necessarily realized, and people will say, oh, I didn't think that was CSI. That's not something that we received from the regulator, but it can be, just as a as a caution for everyone, CSI is much, much broader than what many people realize it is.
And I think, this is just another instance where, getting both sides focused on it, the regulator who's requesting it, or the government agency, and the prudential regulator. And it's almost like, to the extent you can almost step back and say, you guys hash this out or tell us how to do it. It's great, because it really is not, a fight we have much, of a stake in the sense that, other than wanting to make sure that everyone's happy, which, is never.
Yeah, and raising the issue early can help maintain the credibility, which I think Lee emphasized earlier, which is incredibly important when you're dealing with one of these investigations, especially if there's a chance that the bank would be treated as a subject or target of the investigation. A similar issue comes up with suspicious activity reports. And Jen, I think you were going to share a few comments that you had regarding how to handle suspicious activity reports that may somehow be implicated in a subpoena that is served on a branch of a foreign bank.
Yeah, I mean, I know in the materials we have sort of some general rules, but my overarching general rule is, if it involves a SAR at all, just immediately take a step back and really kind of think about what who's asking for it, what it's about, and normally what we do, just because the regulations around the confidentiality of SARs is so serious, that usually what we do is we will engage in a discussion internally, with our financial crimes compliance group that, they usually hold the SAR. And many times what we try and do, and it really depends on, as I said, what agency or what have you is requesting it, is if it looks like we can at least divulge the existence of a SAR, we still don't actually send the text of the SAR itself. We might say, here's the number of the SAR that was filed. If you have access to look up SARs in either the FinCEN database or whatever, you look it up, because we don't want to get in trouble for having, for example, transferred that SAR information the wrong way. We didn't encrypt it, as deeply as what they expect to. I mean, it's really, and that's I think me probably being overly cautious, but, and I'm not saying that has to be done, but it's very similar in my mind as the CSI, because it's like, I'd rather someone, if someone does have access to SAR, the SAR database, they can look it up themselves and get that information. If they don't have access to it, I don't want to give them access to it. That's sort of my general rule. But Lee, I don't know if you have a different standpoint on those things.
No, I think that's exactly right. I think it's just sort of, again, you want to give as much as you can give to the requester, but not any more than, you don't want to go so far as to cross the line. And I think the most important thing is trying to suss out where that line is, and there are going to be gray areas. And when there are gray areas, whether it's SARs or, CSI, it's getting both sides focused on it and having them help you. You can, FinCEN, I think, has a hotline or a number you can call if there's ambiguity. Always, get an answer right away. But there are, I think it's rare that you will be the first, it will, whatever you're facing, whatever question you're facing will be the first time it's been considered. So I think that's the most important thing, sort of knowing what the hot button, where the gray lines are, the gray areas are, and trying to get some clarity and letting Jeff, to the point you raised before, previewing for the requester, whoever sent the request, that it may take some time, right? Because this is a gray area and we have to figure it out.
Right. And Leah, I know that sometimes there can be foreign laws implicated that are analogous in some way to laws that concern confidential supervisory information or suspicious activity reports. Do you have any experience in navigating those types of issues where there's a request for documentation, it's served here in the United States, but turning over that documentation might violate a Japanese regulator or a Hong Kong regulator that oversees the bank, and the attorneys here in the United States have to deal with federal prosecutors in navigating those foreign regulations, whether they relate to confidential supervisory information or suspicious activity reports or something similar.
Yeah, I think it's very, I would, suggest approaching it the same way you would approach data privacy laws, bank secrecy laws, and that is, focus on credibility and when you're speaking with the requestor, making very clear what, you can't do under that law, what you're not sure you can do under that law, what might require permission, and just take them step by step through what it is, what the hoops are that you feel like you need to jump through. And again, just like with data privacy or other, similar restrictive laws and regulations, foreign laws and regulations, the requester, whether it's DOJ or may be very familiar, especially if you're being, if the limits are in a jurisdiction that the U.S. regulator is familiar with, or may even have, close relationships with the regulator. So they will know too, and they may have their own mechanisms as well. So for working through those. So it's very similar. It really is, I think it boils down to, have a sort of a frank and candid discussion and sort of be open to kind of working with and sort of presenting the attitude should be, look, we want to do everything we can to help and get you the information that we can get you. But we have these limits, or we may have these limits, and we're working through them.
Right. Yeah, and I know that Jen was going to talk a little bit about the circumstances under which you'd notify foreign regulators about a U.S. subpoena, which is another issue where you have to have interaction with the foreign regulators. But before we do that, now is the time when I'm going to read the code. So as I think was explained at the beginning of the presentation, to get credit for having watched this video, you need to know the code. So the code for today is 20265. Again, that is 20265. So with that, Jennifer, you are going to discuss a little bit about how to approach the issue of notifying foreign regulators when there's a U.S. subpoena for documents that relate in some way, either directly to the bank's activity in that foreign jurisdiction, or where you think that the foreign regulator that is the regulator of the home office may want to know information about the investigation that is taking place within the United States, even if it doesn't really relate to that foreign jurisdiction.
Mm-hmm. Thanks, Jeff. So I think a lot of this really depends on, and revolves around making sure that you have a strong and credible relationship with whatever that foreign regulator is. And of course, that can be not just dependent on the folks in the US, but also the folks in the whatever foreign jurisdiction, whether it's your home office jurisdiction or what have you, knowing what the expectations of that regulator are. There are some regulators that want to know every single detail. It doesn't matter, where in the world, if it's the home regulator, and I'm sort of saying this because that's how our home regulator in Japan is, the JFSA. Tends toward wanting a lot of information and wanting a lot of information about what's going on globally that that may affect any of the operations back in Japan. So we have several people, of course, in Japan who have a very strong relationship with our supervisory team at the JFSA, for example. What sometimes we'll do is we'll contact them first and say, hey, we have something, and of course this depends on whether or not we can disclose it, exactly or not to our colleagues, which goes back to what we were talking about before. But if it is something where we've kind of decided this is something that we need to disclose, not just to our colleagues, in a home office or in a foreign jurisdiction, but we think it's serious enough that we likely need to disclose it to that regulator, we'll have an internal discussion first. And it really is a big analysis, because it's like, it's a balance, because we don't want to look like, okay, every single subpoena that we're getting in the United States, then we're going to have to turn around and, tell our home office regulator about it, because that just seems extreme. And it's a lot of responsibility on, usually the litigation teams in the US to say, okay, every time we get this. So it's not like it's every single subpoena, and so that's a judgment call that we have to make internally to say, okay, is this something, that they're going to be interested in for some reason? Is it, like Jeff, as you said, are they interested in it because it is going to implicate documents or data coming from that foreign jurisdiction? Or is it something that is so huge and is going to be so expensive? And that really sometimes ends up being where we decide to disclose it as well, and actually both to our US regulators and to some of the foreign regulators, is that we'll say, okay, we've gotten this huge request, we've narrowed it as much as possible, but it looks like we're going to have to do something, and it's going to be very expensive for us to be able to respond to whatever this investigation or subpoena is or whatever. We want to give you notice because this is, not necessarily this is going to be material, but like there's going to be a lot of activity going on, both financially and legally, and just kind of taking people away from their day jobs to be able to pull all the information that's requested. And so we want to make sure that everyone is aware of that. So that's kind of what goes into the thought process. And then of course we're heavily dependent on our contacts in whatever the foreign jurisdiction is to, okay, what is the proper way if we do decide that we're going to give notice? What's the proper way to do that? Do we call a meeting? Do we create a deck with materials? A lot of times, sometimes the materials have to be translated depending on, the comfort in English of the foreign regulator. Are we allowed to send a copy of whatever the subpoena is itself so that they can see it? We need to make sure that we understand that, from the sender. So there's a lot that goes into that. But if it is a big enough, ask, then that is something that we do quite a bit.
Sure. And there's similar standards that apply when you're considering whether or not to notify the US regulator about the subpoena that is served in the United States. So if a federal prosecutor serves a subpoena on the bank should consider whether or not to notify its US prudential banking regulator. And a lot of the same factors weigh in. And I would just, one caveat is that you want to notify the US agency that served the subpoena when you're going to reveal the fact that the subpoena was served to your prudential regulator. So you don't get either of them unnecessarily upset with you. One other thing that I think can be difficult for a foreign bank to navigate, especially a large bank, is to ensure that the subpoena is not somehow inappropriately shared. And I think, Lee, you had a few comments on what a bank can do to avoid inadvertently sharing the subpoena with somebody who shouldn't be getting it in the course of responding to that subpoena.
Yeah, sure. I think, most importantly, you do not want to share a subpoena with anyone who, in a nutshell, could be seen as being, the recipient of like a tip-off. So if it's a client who's a customer under investigation, you really want to make sure that the subpoena or the existence of the subpoena or the existence of the government inquiry doesn't make its way there. Beyond that, you want to maintain confidentiality. They certainly don't want to share it beyond, outside your institution or, beyond a need to know. Sometimes requests, subpoenas, or others will come with a lot of language from a prosecutor around who can share, what you can do with it and what you can't. It's important to sort of pay close attention, but also if you find sometimes language, and there's case law on this, sometimes language is included that may be broader than, or sort of, catches more, maybe read more broadly than actually the law permits. And so my only, advice there would be, if you find yourself in a situation where in order to respond to the request or to take, any proactive risk mitigation steps that you think are important for the bank, whether it's to, close accounts or do other things that, you get some advice on whether or not, like before you stop taking any kind of proactive mitigation or things like that, because you think that you're prohibited from doing so or prohibited from working with the people who you would need to work with in order to take those steps, because that might constitute sharing. That's just a question to raise with folks in legal or externally, because that's important as well to protect the bank.
True. So that was very helpful, and of course today I've learned a lot, as I always do, talking to Lee and Jennifer. There were a couple questions that came in. One question that came in relates to requests that come from foreign jurisdictions, requesting documents from banks that are located in the United States. And that's a little bit outside the scope of what we're going to be talking about today, but it is an important consideration for banks when they're setting up the type of systems that Jennifer described earlier, which is that if you're able to access documents both from the foreign jurisdiction and the United States, that can implicate both the US law regarding subpoenas served in the United States and a foreign jurisdiction law. And the last question that we had related specifically to when a subpoena that is served on a New York branch can compel that branch to produce documents located outside the United States. And that tends to come down to what type of access the foreign branch has to those documents. But also the branch needs to keep in mind that a separate standard can be applied if the subpoena is served directly on the home office as opposed to being served on the New York branch. So Stephanie, I will turn it over to you. Thank you so much for organizing this. It was fun.
Well, thank you all for joining, but I will say we did get one other question from a member. So if you have 1 minute left, most confidentiality agreements signed with clients require notification of the client if a subpoena is received, unless such notice is prohibited. In your experience, when is such notice prohibited?
Right. So this was something that Lee alluded to earlier. And there are specific laws that apply about the types of grand jury subpoenas that are served where a bank is prohibited from sharing the information with the client that a request has been made. And it has to do with the specific criminal violations that underlie the subpoena. And generally, the federal prosecutor that is sending the subpoena will send a cover letter that specifically says whether the bank is prohibited from sharing the information or whether the bank is just asked not to share the information. And so it's important to read that carefully, although the prosecutors don't always get it right. Sometimes some prosecutors will send a cover letter directing the bank not to share information, but they don't actually have the right to direct the bank not to share information. And so that's something that you want to be aware of. And I know before this call, Lee, you had some thoughts on that. I don't know if you have anything to add in response to this question.
No, that's, I mean, I think it's just, the point you raised is exactly right, which is if it's a close call, you're not sure, it's worth getting some advice on.
Great. Well, Jeff, Jennifer, Lee, thank you so much for another very practical, very, what I assume is very useful for our members session on this topic. And it seems like never ending. And I'm sure there's even more we could talk about. So we'll have to think about that. But thank you very much.
Thank you for
Thank you, Stephanie.